Yo, it's JP. I'm going to talk today about workplace sexual harassment and sexual assault, and I'm going to give you a roadmap for how you can report this type of misconduct at work, how you can document your allegations, and then, if necessary, how you can vindicate your rights up to and including litigation. So let's start here, number one, with defining the concepts in play. You have sexual harassment, you have sexual assault. These are two different claims, but you frequently see them in the same case. But there is a pertinent distinction here. Harassment is primarily verbal or visual. Let me explain what I mean by that. Verbal is the typical sexually explicit comments, propositioning, talking about, what type of sex this person likes to have, what they would like to do with you. That is textbook sexual harassment. I also see a lot of cases, and this is really wild, but I've now seen it 20 or 30 times, which means it is an actual thing going on in society. But I see cases where a manager, supervisor, colleague, etc., almost always a man, comes to work and is showing colleagues, typically female colleagues, videos of pornography, right? And it's either pornography that he's watched online, or it's a video of himself, having sex with someone, talking about, like, this is what I like to do, this is what I would do with you. I don't know how society has reached this point of unmitigated fuckery. And yet, here we are, okay? So that is the sexual harassment side of the equation. I'm one of those people who I draw a hard line, okay, where if somebody at work starts touching you without your consent, now we are in assault territory. And in fact, we're in sexual assault territory, because you take a bad actor like the person we just described, right? He's coming to work, he's making sexually explicit comments, commenting on you, commenting on your body, showing these pornographic videos, talking about what he wants to do to you. And then he starts touching you in any way, shape, or form. That is sexual assault. I've been involved in so many of these cases, and in a number of these matters, the lawyers on the other side have said, "Well, come on, what are you talking about? Sexual assault? The guy was just massaging her shoulders." To which I say, actually, point of clarification, okay? You have a 70-year-old executive or boss or supervisor coming into an assistant's office, standing behind her back while she sits at her chair, putting his junk into her back and massaging her shoulders. That is absolutely sexual assault and should be addressed as such via the legal process. So once you cross the line, okay, you got verbal, visual on the harassment, but once you cross the line, once there's any type of unwanted physical contact, unwanted touching, now you are in sexual assault territory. Why is that such a significant distinction or clarification? Well, that's because sexual assault claims have an even broader range of damages, particularly if you get into sexual assault territory. Now you're talking about potentially unlimited punitive damages, especially when you have a bad actor within the company who the company was on notice about. I see this all the time, where you have a habitual bad actor, you have a habitual line stepper, you have it's typically a man, okay? But we've done these cases involving, both male perpetrators, male victims, female victims, etc. But you have a situation where you have a bad actor who is a man who works in the company, has been there for several years. He has done this to multiple women, or we've had cases where it's a male who's a bad actor who did it to multiple men. But for whatever reason, this bad actor is protected. They are friends and family, okay? I call it the friends and family plan. They have friends in high places. They've got an uncle. They've got an aunt. They've got a grandfather, whoever is up the corporate food chain. and the bad actor is protected, and they basically get away with doing whatever they want. And they have done this habitually. The company is aware of it. The company's on notice about it. And the company doesn't do anything because this person has protected status. That is a recipe for a massive sexual assault case with a huge punitive damages verdict. Okay, that's the first point in terms of the law, in terms of sexual harassment, sexual assault, what the framework is there. Okay, number two. Unfortunately, these cases are very common. This happens far more often than most people are aware of. And I think that a lot of people don't come forward in these types of cases and with these types of allegations because they feel ashamed half the time. They blame themselves. They conceptualize some way where it's their fault, it's their responsibility. And I'm here to tell you, absolutely not. Absolutely not. I hate to get so explicit, but I will tell you, like, I've had cases where there were women or men who were being sexually harassed, sexually assaulted at work, and kind of went along with it because they were shell shocked. They didn't know what to do, or even more tragically, these are people who were abused. Right? They were abused or molested when they were children, and they kind of just they froze up. They didn't know how to react, and they've gone along with being sexually harassed, sexually assaulted at work by a supervisor, a colleague, a boss, a manager, and now they're in a place mentally, psychologically, where they feel like it's their fault, like they somehow are complicit in this. You are absolutely not. Nobody should ever be subjected to that type of treatment ever, period, full stop, okay? And the idea of being subject to that sort of treatment at work, at your job, is completely unacceptable. You didn't do anything wrong, right? I have had cases. I have literally had I'm just going to be real with you. I'm just going to be so real with you, okay? I have had cases where a boss, supervisor, manager, etc., basically made giving him blowjobs a condition of a subordinate employee's job, okay? And I had one of these cases come to me where the client, a young woman, single mother, working class, she had gone along with this for, a couple weeks, and then, she had put her foot down. And there was vicious retaliation, and her boss kept making these sorts of terrible demands on her, and she quit. And then when she went to try and find a lawyer, several other law firms turned her down, and they said, well, you went along with it. Yeah, okay, I understand what they're saying, but bullshit, inappropriate, bright line violation, never should have happened. I took the case and I resolved the case successfully on very favorable terms pre-suit, okay? So don't blame yourself. Don't blame yourself if you're in this type of situation. You didn't ask for this. There's no cause for this. You didn't bring this upon yourself, okay? Nobody should ever be treated like this, full stop, period. And you have rights, all right? So if you're going through this type of situation, whether it's sexual harassment, whether it's workplace sexual assault, whether it's a mixture of the two, you got to report. You got to report, okay? First thing I want you to do is, if you received any type of onboarding documents, you received a handbook, you received a workplace policy in terms of discrimination, harassment, workplace violence, etc., I want you to look at that policy, okay? I want you to look at that policy, and I want you to see who it says you're supposed to report to. And this is the reason why I'm doing it this way, okay? Corporate America is full of horse shit, okay? And what they will do is, you'll report it, okay? You report it up the chain, you report it to a different supervisor, because especially in these situations, right? Like, it might be your supervisor, okay? It might be your supervisor is the perp. Your supervisor is the bad actor. And so you're sitting there and you're like, I can't report this to my supervisor. He's the one doing it, okay? Absolutely, absolutely. So we're going to figure out who you should report to. because corporate America, one of the things they do, one of the games they play is they show up when I sue them in these types of cases and they say, well, you didn't report to the person you were supposed to report to, which is, point of clarification, utter dog shit nonsense, and it carries no weight legally. Like if you report pretty much to anybody, okay, up the chain, anybody up the chain should have an obligation to report this type of misconduct to their supervisors. But let's just button it up. Go to the harassment policy. I'm going to call it shorthand the harassment policy. Look it up. If it's a big company, probably a copy of it available online. Just see who it says you should report to, okay? And then I want you to put this in writing, and I want you to blanket the waterfront, okay? I want you to make sure you hit, okay, the head of HR, all right? Your nearest supervisor who is not the perp. So if the perp is your direct supervisor, go to his supervisor, okay? So you want to hit the head of HR, your nearest supervisor in the chain, and then whoever it lists in the harassment policy. We're going to dot the I's, we're going to cross the T's. You do this in writing, okay? And I want you to explain the following things. To the point, direct, don't dance around the issues, right? This is what happens, okay? Anytime you try to be delicate, anytime you try to soft shoe it or sugarcoat it, corporate America is going to turn that around and fuck you with it, okay? So now let's play it. They want to play this way? Let's fucking play, okay? Here you go, right? Direct to the point. I am being sexually harassed and sexually assaulted at work by X person. Here is a summary of the incidents that have occurred. 1, 2, 3, right? That's it, right? I am being sexually harassed and sexually assaulted. Say it point blank, say who did it, and say the who, what, when, where, why, how, okay? List it out. Say, this is affecting my mental health. This is affecting my job performance. I need your help. Please take immediate action, right? 100%, full stop. Full stop, okay? Now, the company has no ability. They have no ability to deny that they are on notice. You hit your nearest direct report, you hit the head of HR, and you hit whoever is listed in their harassment policy as the person that you were supposed to report to. All of these people have various reporting obligations within the company, and especially because you copied the head of HR, the company is point blank on notice. And you've told them you're being sexually harassed and sexually assaulted by so-and-so. You've told them the specifics, the dates, the times, the circumstances, etc. You've said it's affecting your mental health. You've said it's affecting your job performance. And you've said you need them to take immediate action. You've done your job for now, okay? What do you do? What do you do from there, okay? 1, depending on how high up the perp is in the company, you can expect retaliation. You can expect a cover up. You can expect there to be no action taken to help you and to stop the harassment from continuing. All right? Maybe you will be in the 1 out of every 100 cases where the company comes correct and says, we're immediately looking into this. Okay, we've confirmed XYZ. Like, in the meantime, we're going to reassign him. We're going to keep you two separated. He's not allowed to have any contact with you at work. We're going to do a very, a rapid and intense investigation. Like, big companies have all these resources, right? And whenever you get notice of a situation like that, you need to handle it as a big company. You need to handle it like kind of crisis response, right? Where you got a team, dives in, investigates, makes immediate findings and recommendations. But at a minimum, they should separate the two of you. If you still have to continue working with that person on a day-to-day basis, okay, and they don't immediately separate, you go back to the same people that you contacted, right? Go back to the nearest direct report that's not the perp, go back to the head of HR, go back to whoever's listed in the harassment policy as your contact, and you tell them, we need to be separated. I don't want this person around me. He's sexually harassing me, he's sexually assaulting me. I think it's a reasonable expectation that I not have to work with him, okay? Now, if they say, well, if you can't work with him, then we're gonna have to put you on leave without pay. Oh, now you got a retaliation claim. Now you got a retaliation claim right there cooked up, okay? But ask them to separate you. Ask them to keep the perp away from you. That is a reasonable request, okay? 99% of the time, the company is not going to do the right thing. 99% of the time, there is going to be a cover up, there's going to be denial, there's going to be a bunch of shenanigans, and there is a good likelihood that the harassment will continue. In fact, there is a good likelihood that the harassment will even escalate, okay? If it continues, okay, I want you to do the following. Report again, okay? If it continues, the second it happens again, report again immediately, right? The incident happens, you leave the incident, you exit that situation, you're in a safe place where everything is secure, immediately report again, explain what happened again, explain that this is a follow-up, keep it short and to the point. And if it involves anything threatening, okay? If it involves anything threatening, go and file a police report. I am not even fucking with you. Because a lot of people, they will table that, right? They'll be like, oh, I don't really want to do something so drastic. Go to the police, man. So that's a big step. No, if somebody is harassing you, sexually assaulting you, you report them, and now they're escalating and they're still going at you, that's a habitual line stepper. That's a bright line violation. That's a red fucking card. Go to the police, okay? Go to the police, file a police report, because the sooner in this process, okay, that you file a police report, the better for your case. Because what happens is the people who wait, all right, they wait, and then corporate America, big law, the system is like, well, it looks like you were just filing this here police report to try and get leverage for your case. Fuck that noise, okay? File a damn police report if the person escalates it. Now, okay, now you reported to HR originally. You reported again when they didn't do anything. It escalated and then you went to the police, okay? Now, you've got to make the real decision here, okay? I've said it before, I say it again. No job is worth your mental health. No job is worth your psychological well-being. No job is worth your sanity, and no job is worth going to work each day and being sexually harassed, sexually assaulted, treated in this fashion, and just subjected to egregious misconduct. It is not worth it. And people say, well, I got bills to pay and this is a good paying job, et cetera, et cetera. Like, look, I've slept in my car. I've been down and out, okay? Some shit is just a bright line violation, no-go zone. Don't do it, okay? Don't do it. So you got to plan your exit. As swiftly as possible. But before you exit, you got to understand something. When you leave the company is going to destroy whatever evidence exists to prove your claims. When you leave the company is going to destroy whatever documents, writings, emails, reports, claims, etc. They are going to destroy the fuck out of it, because that's who these people are. All right? Like, people are like, oh, you gotta be making this up. Bullshit. They are who they are. They are what they are, okay? Corporate America runs the legal system in America. Corporate America, insurance money, these are the powers that be, okay? These are the powers that be, and they get away with metaphorical murder when it comes to this kind of shit. So they're going to lie, cheat, steal, and destroy evidence. You got to make sure that if you're going to resign, which you probably should do in this sort of a situation, you want to make sure that when you leave, you have the evidence you need. All right. There is a very prominent litigation attorney, trial lawyer, civil rights lawyer out of Baltimore City, who's a friend of mine. What's up, Billy? Who always would tell me, he'd be like, Pollard, I only do cases where I could win the case with the shit I got the first day. Okay. If I don't got the shit right at the beginning of the case, I do not expect to get anything else, right? I do not expect to get any evidence in discovery. I expect the company has destroyed everything. They're going to lie, cheat, steal. So I only do cases where I start the case day one. I'm like, yep, I can go to trial and win on this, right? I like that. So you got to set it up such that day one, okay, you have all the documentation, you have all the evidence you need. What does that mean? Well, that means before you leave, you got to take some screenshots. Okay, you got to take some screenshots. If you sent an email to HR, if you sent a complaint to HR, right, you got to take screenshots of all that stuff. You should be doing that contemporaneous with when you make those reports, okay? And if you're at the point where you're about to leave the company, but you didn't already do it, go back, take screenshots. Any key documents or evidence, make sure you preserve your own copies of it that do not reside in your corporate email or on your corporate devices, because your access to all that's going to be gone, and any evidence that exists on those platforms or devices is going to be gone. Okay. Also, before you leave, and this is where you got to be a little bit savvy about building your case and advocating for yourself. You're going to need corroboration. Okay, you're going to need witnesses. You're going to need contemporaneous accounts of what happened. All right, so it's a lot easier to gather that sort of evidence and that sort of information while you're still inside of the company. Okay, as soon as you leave, it's going to be a lot harder for you to get access to other employees, witnesses, etc., who are inside of the company. And in fact, in many of these cases, the company is going to go to anybody who's a witness, employee, etc., and going to tell them they're not allowed to have contact with you. They're not allowed to communicate with you. They're not allowed to talk with you about your allegations, etc., etc. They're going to circle the wagons. They're going to come up with the party line. They're going to lock that down. They're going to threaten to sue people if they talk to you. I see it all the time, okay? So the best time for you to gather that evidence up is before you leave the company, all right? And you don't have to be explicit about it, okay? Because the vast majority of folks are cowards and are not going to actually take a stand and like come out on your behalf and like speak truth to power. Most people are just afraid and want to keep their own jobs, right? But you want to make sure you got some text messages, okay, with colleagues, with coworkers about the situation, about what's going on, okay? That can be really valuable, powerful evidence. And to the extent there are other women or other victims or targets who have dealt with the same exact situation at the same company with the same perp or the same bad actor, one of the strongest pieces of evidence that you can ever get in a case like this is a written statement by somebody else who has also been the victim of the same type of misconduct, okay? Now, some people will talk, some people won't talk. In a situation like that, a person who has been the victim of the same exact type of misconduct, in many instances, that person will talk, okay? Like other people who just generally witness what was going on, yeah, they might keep their mouths shut. They might be quiet. They might not be willing to do a formal sort of witness statement or declaration. But I've done a lot of these cases, and in most instances where there was somebody else who was also a victim of the same misconduct by the same perp, those folks, 60 or 70% of the time, they're willing to come forward and give you a declaration, okay? So before you leave, you want to lock that down, okay, in whatever way, shape, form, or fashion you can get it, whether it's text messages, whether it's informal conversations, or whether it's somebody who you can really look at and be like, okay, this person is trustworthy, like this person is down for the cause, this person has also been a victim of this same exact misconduct by the same perp, and they're going to give me a written statement. You get a written statement, and it does not need to be in any particular legal format or letterhead. It doesn't have to have any magic language, right? Like it literally just needs to be the person's written statement signed by them, preferably in wet ink, okay? That is huge for proving your case, all right? From this point, you resign, okay? You resign. And when you tender your resignation, you should be explicit about why you are resigning. You put your resignation in writing, you communicate it to the same people, right? Your nearest direct report who is not the perp, the head of HR, and whatever supervisor you were supposed to notify per the harassment policy. You put your resignation in writing and you explain, I am resigning. I was being sexually harassed and sexually assaulted by XYZ. I provided specific documentation, incidents, a summary report, etc. The company did not take corrective action. It continued, and I'm resigning because I'm not going to subject myself to this type of treatment and misconduct on a daily basis, right? Full blown, full stop, period. That's it. Short to the point, okay? Then you get a lawyer, all right? Then you get a lawyer. Can you get a lawyer earlier in the process than this? Yeah, I'm sure you can get a lawyer earlier in the process than this. But for me personally, I'm not taking any cases where the person still works at the company. I am not going to play middleman, right? Where I am routing messages back and forth between my client on one hand, the company on the other side. You resign, okay? If you have the guts and the courage and the fortitude, and you're in a situation like this, if you have the courage and the fortitude to resign and take a stand on principle, then I will take your case. I'm not saying I'll take everybody's case, okay? But that's when you can reach out, and that's when I will consider it. And if it's a real case, I'll take the case. What do you do from there? Well, you either send a swift litigation hold notice, or quickly file an EEOC charge, or quickly send a demand letter, okay? You got to do something out of that, portfolio there. Why? Well, document retention obligations, okay? Document retention obligations. Once again, these companies are exactly who you think they are. They do the same shenanigans they do, and they're going to keep doing them, okay? They're going to lie, cheat, steal. They're going to destroy evidence. And so promptly upon your separation from the company, you need to hit them with something that puts them on notice of, possible litigation, future litigation, and that triggers their document retention rights. Because otherwise, what are they going to do? They're going to wipe everything. They're going to wipe everything. To the extent you had any documents, evidence, etc., in your inbox, or they have it on emails with HR, they're going to wipe everything. They're going to destroy everything. So you send them either a demand letter, you file an EEOC charge, you send them a document preservation / litigation hold notice, something that formally puts them on notice and gets them on the hook if they destroy that stuff, okay? From there, all right, you got to file an EEOC charge, okay? Some of these claims will potentially flow through Title VII or a state law corollary, like in Florida, it's the FCRA. And for those types of claims, so statutory claims for discrimination, sexual harassment, hostile work environment, those statutory claims flow through the EEOC. You never go to the state agency, like in Florida. You never go to the Florida Human Rights Commission. You just go to the EEOC. I've talked about that as well, particularly in the American South and the old Confederacy. The state agencies that handle these types of administrative claims, they are designed to be rights stripping or rights minimizing, okay? The EEOC is at least rights neutral in this context. So you go through the EEOC, you file your charge. That's going to preserve your statutory claims. The statutory claims are significant, particularly in cases where you don't have a sexual assault claim. If you have a sexual assault claim, the statutory claims are less significant when it comes to compensatory and punitive damages, because the assault claim gets you a better mixture of compensatory and punitive damages, but the statutory claims are nonetheless valuable because they create an attorney's fee hook. You don't get attorney's fees if you prevail on a tort claim, a negligence claim, which is the assault claim, okay? You're not going to get attorney's fees on that claim. It's a common law claim. There are no attorney's fees awarded or awardable on that claim. You're going to get fees if you prevail on a statutory claim. So you run both. You're going to run the Title VII FCRA plus the sexual assault claim. So you're going to maximize all of your different buckets there. You're going to maximize your attorney's fee bucket, and then you're going to maximize your compensatory and punitive damages bucket. The other side might get wise, and they might reach out and say they want to go to an EEOC mediation. I've said it before. EEOC mediations are the Dollar Tree of mediation. You go to the Dollar Tree, you shop at the Dollar Tree, you're looking to spend a couple bucks. When a big company or a corporate defense lawyer goes into EEOC mediation, they are looking to spend a couple bucks. They are not looking to pay real money, because the EEOC mediation process is not designed to get real money. It's nickel and dime bullshit, and you want to stay out of it. You want to refuse, okay? You want to refuse. They ask you want to do EEOC mediation? No, we don't. We're not interested. End of story. Sometimes the EEOC investigator will try and badger you, especially if you don't have a lawyer. The EEOC investigator will just keep coming back to you, trying to convince you, trying to encourage you to do EEOC mediation. Again, that's why you're best served with a lawyer, okay? Call 5, call 10, call 20, okay? If you have a real case, you'll find one. But whether you have one or not, refuse to do EEOC mediation. From there, what do you want to do? If you haven't already done it, You want to make a large dollar settlement demand. Okay. Why is that important? Well, it's important because most of these cases implicate insurance coverage, and insurance companies work a very specific way. One of the ways that insurance companies work is they will slot the case at whatever they consider the maximum possible level of exposure. And how do they do that? Well, it's based on what you demand, okay? Based on what you demand. If you come in and you demand $200,000, the insurance company, in their modeling of things, is going to put the maximum value of the case at $200,000 because that's what you demanded. Okay. So for their purposes, their risk discounting, evaluation, analysis, financial models, etc., they look at the case and they say, okay, they have a whole model built on that. They're like, okay, they demanded 200,000, right? That's the kind of max value that they think you'll ever get for the case. And then they discount that and they're basically, okay, they demanded 200,000. We can get this thing done for, maximum 80, right? That's how they look at shit. So what do you do in a case like this? Make a massive fucking demand. Tell them you want $2 or $3 million. That is how the sausage is made. And then from there, okay, you got to have a lawyer, all right, because that's going to maximize your rights, it's going to maximize your recovery, it's going to maximize your leverage. You make a huge dollar amount demand, and then you consider going to mediation, but not EEOC mediation. Not EEOC mediation, not through the EEOC, and not with an EEOC mediator. You consider going to private mediation with a private mediator who your attorney trusts, a mediator who is reputable, a mediator who your attorney knows is on the up and up and is legit. And you consider going to private mediation if the company has indicated that it understands the severity of the claims and that it understands the real universe in terms of dollars wherein the claims could get resolved pre-suit. And if they're not willing to pony up, then you file a lawsuit and you litigate the case. But that's a whole nother story. Jonathan Pollard, happy Tuesday.